The Muslim judge interrupted her before she finished the first sentence. He leaned forward, eyes fixed on the small silver cross resting openly against her blouse, and raised one finger. He did not ask for a pause. He stopped her. He asked her age instead of her argument. When she answered, 17 Christian, his mouth curved into a thin smile. He said the court was not a church. He said belief carried no authority here. He said it evenly. He said it as fact, not opinion. He did not pretend neutrality. He named it. He said his background had taught him discipline and restraint. He said Islamic law understood hierarchy better than Western Christianity ever had.
If you stand up with real Christians, don't forget to hit that subscribe button and comment from where are you watching.
He said Christian courts had confused morality with power for centuries. He said this courtroom would not repeat that history. The words landed without apology. The clerk froze. The gallery stiffened. The girl stood straight. Her hands rested on the table. She did not respond. She waited for recognition. He denied it. He questioned her presence. He asked who had allowed a Christian teenager to address the court directly. He asked if her parents believed faith replaced qualification. Each question stripped ground. Each one reframed her as a problem to be managed. When she opened her mouth, he cut her off again. He said Christian girls were taught to speak with confidence before earning it. He said humility was preached but never practiced. The cross became his focus. He asked if she understood the symbolism she was displaying. He said Christian symbols carried a legacy of judgment and coercion. He said their presence disrupted neutrality. He said Muslims had learned to respect secular authority in ways Christians resisted. His voice stayed calm. His control stayed total. The room stayed silent. Silence worked for him. She inhaled once. Her jaw tightened. The paper in front of her shifted slightly as her fingers adjusted it. The movement stopped. She asked politely to finish her opening statement. She cited procedure. She cited her allotted time. Her voice did not rise. The judge tilted his head. He said procedure did not protect performance. He said courts were not stages for Christian expression. He said if she wanted to testify about faith, she could do it elsewhere. He framed his contempt as education. He said young Christians often mistook tolerance for weakness. He said society had indulged that confusion too long. He said Islam taught order, not entitlement. He said the law required submission to structure, not attachment to symbols. He spoke slowly. He let each sentence settle. He watched her face as he spoke. He looked for a collapse. It did not come. The case itself faded. The legal dispute on record became irrelevant. The hearing shifted into correction. A Muslim authority instructing a Christian subordinate. He controlled the pace. He controlled the questions. He controlled when she could breathe. He asked again how old she was. He asked again who advised her. He asked again why she thought her voice belonged there. Each repetition was deliberate. Each one reminded the room who decided worth. Her guardian shifted in his seat. He started to speak. The judge raised his hand. He said guardians often confuse protection with interference. He said Christian families had a habit of inserting belief into secular systems. He warned that further interruption would be noted. He smiled when he said it. The warning was clear. No one spoke again. She finally spoke when allowed. She did not defend Christianity. She did not accuse him of bias. She stated her legal position. Clear, structured, grounded in statute. The judge listened for less than 10 seconds before interrupting again. He said her tone was inappropriate. He said confidence without credentials was arrogance. He said Christianity encouraged moral certainty without competence. He struck her words down with a gesture. He told the clerk to move on. She felt the heat in her face. It stayed there. Her eyes did not drop. Her hands did not clench. She asked again for her statement to be entered into the record. The judge laughed quietly. He said the record did not need sermons. He said Christian grievances were always emotional. He said nothing of substance had been offered. He told the clerk not to record it. The humiliation was public. It was procedural. It was clean. No shouting. No insults that could be quoted. Just authority applied unevenly. The bailiff did not move. The prosecutor did not object. The imbalance was institutional. That made it stronger. He ended the exchange by instructing her to sit and observe. He said courts rewarded discipline. He said humility was learned through listening. He said Christians often struggle with that lesson. The words were calm. The meaning was sharp. She complied. She sat. Her back stayed straight. The cross stayed visible. As the hearing moved on, she became invisible. Her motions were skipped. Her notes were ignored. When her name was mentioned, it was paired with doubt, inexperience, youth, faith. Each word carried weight. Each one narrowed her space. She absorbed it all. She did not react. Reaction was what he wanted. When the session ended, the judge addressed her one last time. He said he hoped she had learned something about secular law. He said belief belonged in private life. He said the court would not bend for Christian sentiment. He said it evenly. He said it as closure. She stood. She gathered her papers. Her fingers were steady. She looked at him once. She did not argue. She did not plead. She said she respected the court. She said she would continue according to the rules. She said it clearly enough for the record. The judge nodded, amused. He believed the lesson had landed. As she left, the weight followed her. Not fear, not shame, indignation. The kind that settles deep and sharpens focus. The kind born when authority mistakes restraint for weakness. The kind that waits. Would you have remained silent, knowing your faith was being reduced to a liability in the name of law? The order came without ceremony. The Muslim judge did not raise his voice. He did not call it punishment. He called it compliance. He said religious symbols compromised neutrality. He said Christian imagery carried historical dominance that courts could no longer tolerate. He said the cross was not jewelry. He said it was messaging. He looked directly at it when he spoke. He waited for her to remove it. She did not move. She did not ask for time. She did not ask for clarification. She said one sentence. She said the cross was not a statement to the court. She said it was a statement of who she was. She said removing it would be a lie. Her voice stayed level. The room stayed silent. The judge's jaw tightened. He wrote something on his pad and did not look up. He reframed immediately. He said this was not about Islam versus Christianity. He said that twice. He said this was about order. He said secular law demanded restraint from believers. He said Christians struggle with that demand because they believe their faith excused visibility. He said Muslims had learned discipline in hostile systems. He said Christians had not. He said it calmly. He said it as instruction. He asked if she understood the authority of the bench. She said yes. He asked if she understood that defiance carried consequences. She said yes. He asked if she was prepared to accept them. She paused. One breath. Then she said yes again. The word landed heavier that time. The judge looked up. He studied her face. He expected fear. He found resolve. That irritated him. He escalated without announcing it. He struck her next motion as improper. He denied her a continuance others received routinely. He questioned her standing on matters already conceded. Each action stood alone. Together, they formed a squeeze. He never referenced the cross again. He let the system apply pressure where he did not have to. Her appointed attorney leaned toward her and whispered. He said this was not the hill to die on. He said judges rotated. He said symbols could be put back on later. He said strategy required flexibility. She listened. She nodded once. Then she said she would not negotiate her faith for procedural comfort. The attorney exhaled. He said nothing more. He had heard the finality. The judge noticed the exchange. He smiled slightly. He said counsel should advise clients against ideological rigidity. He said courts rewarded adaptability. He said Christianity often produced moral absolutism that clashed with modern systems. He said it like a diagnosis. He said it with authority. No one challenged him. After the hearing, the consequences became explicit. A notice appeared in the docket, questioning her eligibility to participate further. The language was careful. Professional standards, court decorum, potential bias. The implication was clear. The cross was now a liability. The refusal had been logged. The system had memory. Emails followed. Polite, Cold. One suggested she reconsider her presentation. Another warned of reputational impact. A third mentioned future opportunities. None mentioned religion directly. They did not need to. The message was uniform. Conform or be isolated. Remove the symbol or be marked difficult. At home, the discussion was short. Her mother asked if the court could force her. Her father asked what the rule actually said. She answered both questions with documents. She showed them the statute. She showed them the absence of prohibition. She showed them the discretionary language being stretched. Her father nodded slowly. He said then, this was no longer misunderstanding. He said it was intent. She returned to the record. She read every ruling. She compared timelines. She noted deviations. She tracked how discretion bent only one way. She did not frame it as persecution. She framed it as pattern. She did not complain. She prepared. The judge believed pressure would teach her silence. He believed time would erode her resolve. At the next appearance, he tested her again. He asked if she had reconsidered. He said it lightly. She answered calmly. She said no. The cross remained. He nodded. He said the court would proceed accordingly. The phrase sounded neutral. It was not. It was a warning. By the end of the session, her participation had been narrowed further. Her voice had been reduced to responses. Initiatives were blocked. She was present but constrained. The humiliation was no longer sharp. It was sustained, designed to teach compliance through attrition. She left knowing the next step would not be verbal. It would be administrative. The judge would not argue with her faith. He would bury it under procedure. He would let policy do what confrontation could not. How long can a system pretend neutrality while targeting one belief with precision? The containment began quietly. The judge issued no dramatic ruling. He issued reminders. He cited scheduling conflicts. He adjusted timelines. Each adjustment favored the other side. Each delay landed on her. When she asked for explanation, the response referenced discretion. When she asked for equal treatment, the answer referenced experience. When she referenced the rule was reinterpreted. The system stayed polite. The outcome stayed the same. At the next hearing, he addressed her faith again, indirectly. He spoke about objectivity. He spoke about the danger of moral certainty. He said Christian belief had historically blurred the line between law and conscience. He said courts could not function when participants believed themselves guided by something higher than statute. He never said her name. He looked at her when he said it. The room understood who he meant. He began documenting concerns, not accusations. Concerns. He questioned her professional judgment. He questioned her emotional distance. He questioned whether her visible Christianity compromised her ability to engage impartially. Each concern was filed. Each one created paper. Each page narrowed her future options. He was building a record. Records outlast arguments. Her responses were entered late, not because she missed deadlines, but because her submissions were under review. By the time they appeared, decisions had already been made. When she pointed this out, the judge said courts moved quickly. He said adaptation was required. He said rigidity was dangerous. He said Christians often clung to form over function. He smiled when he said it. Others began to notice, not openly, in side glances, in hallway pauses. One clerk avoided her entirely. Another whispered that she should be careful. A junior attorney told her the judge had a reputation for discipline. He said discipline often fell hardest on those who resisted assimilation. He did not mention religion. He did not have to. She adjusted nothing. She spoke less, but when she spoke, she cited precisely. She removed emotion from her tone. She removed hesitation from her answers. She became exact. The judge noticed. He interrupted more. He asked her to repeat herself. He asked her to clarify what was already clear. He controlled the pace to regain advantage. Then came the review notice. Formal, neutral language. The court would examine whether her continued participation met professional and ethical standards. The notice cited decorum. It cited impartiality. It cited public confidence. It did not cite law. That absence mattered. She read it twice. Her hand shook once. Then it stopped. Her attorney advised withdrawal. He said the risk was growing. He said reputation mattered. He said judges talked. He said she was too young to carry this mark. She thanked him. She said she would continue. He said then he could not protect her. She said she was not asking him to. That ended the conversation. Preparation became isolation. She worked alone. She reviewed prior cases involving religious expression. She mapped outcomes. She noted which judges invoked neutrality selectively. She found patterns, not conspiracies. Patterns. The judge's pattern stood out. His rulings against Christian expression were consistent. His tolerance elsewhere was flexible. The discrepancy was measurable. At the review hearing, he framed the issue as concern for her development. He said courts were harsh places. He said young Christians often mistook endurance for strength. He said perhaps this environment was not appropriate for someone so visibly committed to belief. He said it gently. He said it publicly. He invited agreement. Silence followed. She responded calmly. She cited the statute governing decorum. She cited the absence of any prohibition. She cited precedent where religious symbols were permitted. She did not mention Islam. She did not accuse bias. She spoke only of law. The judge listened without interrupting. That worried him. He deferred decision. He said more review was needed. He said caution was appropriate. He said integrity demanded patience. The delay was strategic. It kept pressure alive. It kept her uncertain. It kept her contained. Afterward, the consequences deepened. A mentor withdrew support. A recommendation stalled. Opportunities evaporated quietly. No one confronted her. They distanced themselves. The system rewarded distance. She felt it. She logged it. She did not respond publicly. She waited. At home, her father asked what the end looked like. She said exposure. He asked how. She said through the record. She said arrogance always left fingerprints. She said power grew careless when it believed resistance was broken. She said the judge was close to that point. The next filing from Chambers confirmed it. An amended notice included a citation that did not apply. A regulation misquoted. A standard misused. It was small. It was precise. It was wrong. She circled it. Then she smiled. Just once. How long can containment hold before the pressure reveals the flaw it depends on? The judge moved faster after that. Confidence replaced caution. He shortened response windows again. He issued guidance from the bench that exceeded his written authority. He referenced policies that applied to staff, not parties. He believed no one would challenge the difference. He believed she would retreat. The system had taught him that resistance eventually folded. He relied on that lesson. He began speaking about her as if she were absent. He described her faith as an influence that needed management. He said Christian visibility threatened public confidence. He said neutrality required active correction. He said this while ruling on unrelated matters. He said it often. He said it comfortably. The record thickened. He did not seem to notice. She noticed everything. She marked each statement. She time-stamped each deviation. She did not object reflexively. She waited for accumulation. One error could be dismissed. A pattern could not. The judge's tone shifted. He stopped masking irritation. He began lecturing. Lectures created language. Language created evidence. At the next procedural conference, he cited a conduct code that did not apply to her role. He read from it. He summarized it incorrectly. He then used it to justify restricting her participation further. No one corrected him. No one checked the citation. The ruling moved forward. He smiled. He believed the matter settled. She requested clarification in writing, not confrontation. Clarification. She asked which subsection applied. She asked how the code extended jurisdictionally. The response came quickly. Too quickly. It restated the same error. It doubled down. That mattered. Errors repeated became positions. She prepared a narrow motion, not emotional, not accusatory. She attached the correct statute. She attached the misquoted provision. She aligned dates. She showed the mismatch. She did not mention religion. She did not mention the cross. She let the law speak. The filing was clean. The contrast was sharp. The judge reacted by striking the motion. He said it was improper. He said it challenged the court's authority. He said such challenges were inappropriate from someone under review. He said this without citing a rule. He said it orally. He did not put it in writing. That choice mattered too. The strike triggered a procedural consequence he overlooked by acting orally where written justification was required. He opened a path. She knew the path. She did not rush it. She requested the transcript. She requested certification. She followed the steps exactly. The system had rules for this. He had ignored them. When the transcript arrived, the errors stood plain. The misquoted code, the jurisdictional overreach, the oral strike without written basis, the judge's commentary on Christianity attached to each action. It was not dramatic. It was bureaucratic. That made it lethal. Her attorney read it twice. He did not smile. He said this was serious. He said judges survive many things, but records did not forget. He said oversight bodies cared about process. He said religion made the matter sensitive. He said sensitivity cut both ways. She listened. She nodded. She authorized the next step. The filing went out. Limited scope. Procedural violation. Request for review. No rhetoric. No accusation. Just sequence. Just rule. Just deviation. It did not name bias. It did not need to. The record carried it. The judge received notice the same afternoon. His demeanor changed at the next appearance. He was controlled again, measured. He avoided commentary. He avoided eye contact. He denied nothing. He postponed everything. He said review was pending. He said caution was appropriate. The confidence was gone. The misstep had landed. Outside the room, the tone shifted. Clerks returned emails. Deadline stabilized. The squeeze loosened slightly. Not fairness. Restraint. The system sensed oversight. Systems behave when watched. She did not celebrate. She prepared. The next phase would not be loud. It would be administrative. The judge had built his authority on being untouchable. Now the touch was procedural. That was worse. Arrogance always believed the rules were for others. It forgot that records did not share that belief. The review did not announce itself with noise. It arrived as paperwork, requests framed as routine, language scrubbed of accusation. The judge received them and smiled at first. He had seen reviews before. They came and went. He believed authority diluted scrutiny. He believed his position insulated him. He believed the system remembered who controlled the room. The first request asked him to justify the conduct code he had cited to restrict her participation. Not generally. Specifically, it asked for the subsection, the jurisdictional basis, the applicability to a party who was not court staff. He responded confidently. He paraphrased. He cited intent instead of text. He assumed familiarity would substitute precision. It did not. The second request asked why a ruling that required written justification had been delivered orally. It asked why no written order followed. It asked whether the deviation complied with internal procedure. The questions were narrow. They were surgical. They did not accuse bias. They demanded alignment. Alignment was where his answers began to fray. He answered quickly, too quickly. Speed revealed assumption. He claimed discretionary authority that did not exist. He blurred administrative guidance with enforceable rule. He relied on general language instead of statutory mandate. Each response widened the gap between what he asserted and what the record allowed. At the next hearing, he addressed the review without being prompted. He framed it as routine oversight. He said transparency was a strength of the judiciary. He said judges were frequently reviewed. He said nothing would change. Then he limited her speaking time again. He did it reflexively. He did it because control was habit. The contradiction was recorded. She noticed a shift immediately. His voice was tighter. His interruptions shorter. He avoided extended commentary. He avoided religion entirely. He avoided looking at her. That avoidance mattered. It marked awareness. Awareness came after certainty cracked. She spoke only when allowed. She did not test boundaries. She did not provoke correction. She delivered her points with mechanical precision. Statute, precedent, application. The judge listened. He interrupted once, then stopped himself. Silence followed. The silence belonged to her this time. Outside the courtroom, the atmosphere changed. Not dramatically. Subtly, clerks answered emails. Deadlines stabilized. Motions were acknowledged instead of delayed. The system had sensed oversight. Systems always behave differently when watched. The squeeze did not vanish. It loosened. Then the supplemental inquiry arrived. It referenced a pattern, not misconduct. Pattern. It listed instances where discretion had been applied unevenly. It asked whether any non-procedural factors influenced those decisions. It did not mention Christianity. It did not need to. The record already did. The judge's response was defensive. He framed his actions as protective. He cited concern for professionalism. He referenced public confidence. He avoided specifics again. Avoidance under scrutiny was visible. Visible avoidance drew more questions. At the following hearing, a second judge sat quietly to the side, observing. No introduction. No explanation. Just presence. The original judge stiffened. His ruling shortened. His tone flattened. He did not lecture. He did not educate. He did not moralize. The performance had ended. She noticed something else in the filings that week. A footnote reference to an internal memo, authored years earlier, written by the same judge. The memo argued for heightened scrutiny of religious expression in court. It framed Christianity as historically dominant and therefore incompatible with neutrality. The memo had never been adopted. It existed anyway. It matched his language. It matched his behavior. It connected motive to action. She did not attach it. She marked it. Oversight bodies did not reward emotional dumping. They rewarded sequence. She was building sequence. The judge attempted to regain ground through efficiency. He shortened hearings. He cut time without explanation. He framed it as docket management. Under normal conditions, that would pass. Under review, it required justification. The observing judge took notes. The clerk paused. The moment settled into the record. A written request followed. Polite, narrow. It asked for the basis of the time reduction. The judge responded late. He cited general authority again. He did not cite rule. He did not cite exception. He relied on status. Status was no longer enough. Her attorney called that evening. His tone was different. He said the review had shifted focus. He said it was no longer about her conduct. He said it was about the judge's use of authority. He said the memo might surface. He asked if she was prepared for attention. She said attention was irrelevant. She said procedure was sufficient. The next notice confirmed it. A preliminary finding. Improper application of conduct standards. Failure to issue required written rulings. Pattern of discretionary imbalance. The language was restrained. The implication was final. The judge was now contained by the same mechanisms he had used to constrain her. At the next appearance, he said nothing beyond necessity. He avoided commentary. He avoided correction. He ruled narrowly. The room felt the absence of confidence. Authority without certainty felt brittle. The shift was unmistakable. She sat with her cross visible, unchallenged, not because belief had been embraced, because procedure had intervened. The law had done what argument could not. Power had revealed itself not through force, but through carelessness, and carelessness had left a record. The application of the law did not feel like justice at first. It felt like waiting. Forms moved. Notices circulated. Deadlines appeared and vanished. The judge was instructed to respond again, this time to a consolidated inquiry. The questions were no longer isolated. They were sequenced. Each answer had to reconcile with the last. Consistency was required. Consistency was where he failed. He submitted a memorandum defending his authority. He framed his actions as protective of neutrality. He argued that visible Christianity risked influencing perception. He claimed equal treatment across cases. The language was polished. The problem was comparison. The reviewers compared his claims to transcripts. The transcripts compared poorly. They noted where he interrupted her and not others. They noted where time limits appeared selectively. They noted where conduct standards were applied outside jurisdiction. They noted where oral rulings replaced required written orders. None of it was dramatic. All of it was cumulative. Cumulative error carried weight. A directive followed. Temporary reassignment of the matter, not punishment. Safeguard. The language mattered. Safeguards implied risk. Risk implied fault. The judge complied without comment. He had no choice. Compliance did not look like concession. It looked like containment. The next hearing opened under a different name on the bench. The transition was quiet. No announcement. No explanation. The new judge reviewed the docket methodically. She acknowledged filings previously ignored. She restored timelines. She asked if any party wished to address prior procedural concerns. The invitation was neutral. The effect was not. She spoke briefly, only what was necessary. She cited the restored schedule. She confirmed the scope of participation. She asked that the record reflect prior denials now corrected. The new judge nodded. The clerk typed. No commentary followed. The record shifted. Outside the room, the original judge's presence faded. He no longer passed in the hall. His chambers did not issue guidance. His voice no longer framed the space. The system had moved him aside without spectacle. That was how institutions protected themselves. A formal notice arrived days later. Findings finalized. Improper application of conduct, standards confirmed. Failure to issue required written ruling sustained. Pattern of discretionary imbalance acknowledged. The remedy was administrative. Mandatory training. Removal from certain case types. Public censure recorded internally. No headlines. No press. The consequences were durable. He attempted a response. It was brief. He accepted guidance. He rejected characterization. He emphasized intent. Intent did not matter. Process did. The file closed without a satisfaction. Closure did not require it. The effect was immediate and subtle. His colleagues adjusted distance. Invitations stopped. Committees reshuffled. Authority diminished quietly. In institutions, quiet diminishment was final. There was no appeal that restored reputation. One's process branded it unreliable. For her, the change was concrete. Participation restored fully. Motions heard. Questions answered on substance. No references to faith. No request to remove the cross. The silence around it felt different now. Not permission. Recognition of boundary. She noticed her hands no longer trembled when she exhaled. She noticed her voice stayed even without effort. She noticed that dignity returned faster than she expected. It returned not because she demanded it, but because the system recalibrated. The case proceeded. Facts mattered again. Law mattered again. She argued without obstruction. The outcome followed merit. It was not perfect. It was fair. Fairness was enough. When the ruling issued, it referenced corrected procedure. It referenced restored timelines. It referenced no religion at all. That absence was a point. The law had returned to itself. She left the building without looking for him. There was nothing left to say. The humiliation had been public. The correction had been administrative. The restoration had been quiet. That sequence mattered. Power had been applied. Then it had been checked. The check did not roar. It wrote, and writing endured. Restoration did not arrive as relief. It arrived as normality. The hearings resumed on schedule. Motions were addressed in order. Questions were answered directly. No one commented on her faith. No one referenced the cross. The absence of pressure exposed how heavy it had been. Normality revealed damage by contrast. She tested the space cautiously, not by provoking, by existing. She spoke when recognized. She cited law. She paused when interrupted and waited to continue. The new judge allowed it. No lectures, no corrections. The room adjusted around the rules instead of bending them. That adjustment was a restoration. The clerk treated her filings like everyone else's. Time-stamped, logged, answered. That had not happened before. She noticed immediately. The system was not kind. It was consistent. Consistency felt like dignity after disorder. Others noticed too. Attorneys who had avoided eye contact now nodded. One apologized quietly for earlier advice. He said survival instincts ran deep in court culture. He said resistance made people nervous. She said nothing. Apologies were not the point. The point was that the record had held. The cross stayed visible. It no longer drew attention. That mattered, not because belief had been validated, but because it no longer triggered control. The law had reasserted its limits. Belief existed within those limits without submission or privilege. That balance was a victory. A procedural memo circulated weeks later. It clarified decorum standards. It emphasized written rulings. It reminded judges of jurisdictional boundaries. It did not reference her. It did not reference the review. Everyone knew why it existed. Institutions preferred quiet correction to public admission. Quiet correction still changed behavior. She read the memo once. She saved it. She did not celebrate. Restoration did not require ceremony. It required continuity. The rules worked because someone had insisted they be followed. At home, her father asked if it was over. She said the conflict was. The lesson was not. He asked what the lesson was. She said power depended on silence more than force. She said law depended on record more than courage. She said faith depended on neither. It depended on truth lived under pressure. The original judge did not return to her docket. Months later, she heard he had been reassigned permanently. No explanation. No statement. His absence became routine. Routine erased authority faster than outrage ever could. She encountered him once in passing. Brief. He looked at her and looked away. No apology. No confrontation. The moment passed without weight. That, too, was restoration. Power that could not speak no longer ruled. Her case concluded with a written decision grounded in statute. Clear, dry, effective. It restored what had been denied. It did not mention the conflict that preceded it. Law rarely did. Law moved forward and left friction behind. She archived the file carefully, not as a trophy, as a reference. One day, someone else would need it. Someone younger. Someone quieter. Someone told to remove what defined them. Records existed, so people did not have to fight the same battle twice. Restoration was not vindication. It was continuity. The court returned to order. She returned to work. The faith that had been mocked remained unchanged. It had not needed the court's permission. When dignity is restored without apology, it lasts longer. The record closed without ceremony. No announcement. No acknowledgement of what had preceded it. The final order arrived as a document, stamped and dated, restoring every procedural right that had been narrowed. It cited statutes. It cited timelines. It cited nothing else. The absence of commentary was intentional. The law corrected itself without narrative. That was how it endured. In the weeks that followed, the effects became visible through routine. Hearings began on time. Interruptions were rare. Written rulings followed oral ones as required. The court did not become gentler. It became predictable. Predictability was justice's quiet form. Those who had learned to survive by anticipating bias noticed the difference first. Her presence no longer drew attention. She spoke, and no one looked at the bench for reaction. She cited law, and the response addressed law. The cross remained where it had always been, not defended, not challenged. It existed without negotiation. That normality was the final restoration. The former judge's name disappeared from schedules. His prior rulings were cited less. When referenced, they were footnoted cautiously. Authority eroded not through disgrace, but through omission. In institutions, omission replaced memory faster than scandal ever could. The system had absorbed the correction and moved on. She was asked once quietly if it had been worth it. The question came from someone younger, someone watching. She answered without hesitation. She said worth was a wrong measure. She said some things had to be recorded because silence taught the wrong lesson. She said faith that hid to survive learned how to disappear. Her work continued. New cases, new files, different pressures. The experience did not harden her. It clarified her. She no longer mistook procedure for protection. She trusted it, but she verified it. That distinction mattered. Months later, a training memo circulated again, updated, expanded. It addressed neutrality with precision. It defined boundaries. It warned against discretionary overreach. It was anonymous. Everyone knew why it existed. No one said her name. The record had done its job without credit. At home, the conversation changed. No longer about endurance, about responsibility. Her father asked what she would do if it happened again. She said she would do the same thing, faster. She said the law rewarded clarity eventually. She said faith provided the patience to wait for eventually. The system did not apologize. It did not need to. It corrected itself in the only language it trusted: documentation, sequence, rule. That correction would remain long after personalities rotated out. That was the point. She archived the case one final time. Labeled, indexed, ready, not as a victory, as precedent. Something solid enough for someone else to lean on when authority mistook itself for truth. The court returned to order. The law returned to form. Her faith remained where it had always been, visible, unashamed, and unmoved. The record closed. The lesson stayed.